Did a debt collector win a court judgment against you, even though they had no real proof? What if I told you that you can legally cancel or vacate that judgment using powerful consumer laws most people don't know about and won't even talk about? In this video, I'm going to be showing you step by step how to cancel a debt judgment, what paperwork to file, and how to fight back even after the court has ruled the judgment. Now, I've been studying debt law, consumer law, court procedures, and consumer protection tactics, and I'm here to help you take back control. Okay? Now, thank you guys for watching this video. If you're brand new, go ahead and leave a like. Make sure to subscribe. If you tap in with me and you invest in me, this is the type of videos that I'll be dropping on a consistent banger. Happy Friday to you guys. If you're watching this on a Friday, thank you once again for using your Friday to watch this video instead of going out, partying, this, that, and the third. You guys are the chosen ones, okay? And if you and I are on the same frequency, then this video will be perfect for you, okay? One of the things that I want you guys to understand is that you have rights as a consumer, okay? And you can challenge these debt collectors. You can put these debt collectors in a position where they are sweating under their armpits, right? And a lot of times we think we can't do that. So my job today, man, is to put you guys on game and essentially put you in a position where you are now able to challenge the system that we are in, okay? Now let's dive into what a court judgment is, okay? A court judgment is a final decision made by a court or a tribunal after considering all the relevant evidence and legal arguments, okay? It settles a dispute between parties by determining who is in the right and what remedies, if any, should be awarded, okay? To break that down, man, a court judgment is a legal ruling that says you owe a debt, all right? And a lot of times people think that this is the end, okay? And typically judgments can lead to wage garnishments, bank levies, or even liens, all right? Now, this is the reason why people lose debt cases, okay? The reason why they lose debt cases is because most people lose by default, meaning they either didn't respond or didn't show up to the court proceedings, okay? And debt collectors often win using the lack of response and the lack of legal knowledge that people typically don't know or even use. I have a lot of people that go and watch my videos and won't take action on the information that they receive. They are scared. They have anxiety when it comes to going into court, and probably because of past traumas, probably because of what you see online. Not only is the system put in place to discourage you, but it's so deeply rooted that there are people who will be in the comment section to discourage you as well. And if you're that type of person, this video is not for you, okay? It's only for the people that believe. It's only for the people that want to take action on this. And sometimes it'll take you being with your back against the wall in order for you to take this serious, okay? Now, a lot of times judgments are based off of hearsay and no original contract or even bad documentation. A lot of times those judgments happen because you just didn't challenge them, okay? You didn't tell them, you didn't challenge their documents. You didn't challenge whether the contract was valid. You didn't challenge whether the debt was valid prior to the judgment, okay? So I'm gonna be telling you guys how to be able to flip the script so that you are not in a position to where you are piling up judgments, but also at the same time, these judgments go on our credit report, affect our credit report, and we think that we cannot move forward in life because our credit score is down. But I'm here to put you above the system because you are above the system, Yes, the system is rigged, but you are above it. Okay? Or over it. You stand over the system. The people who stand under the system are the people who don't know the law. Okay? Now, we're about to talk about some laws that can help you cancel a judgment. But before we do that, I want you guys to understand that everything that I'm talking about is not legal advice. Okay? I always tell you to do your due diligence and consult a legal professional before you execute on these strategies. But the most important thing is for you to tap in with the law and actually learn it yourself. You can watch me for 30 to 40 minutes and still not overstand the information, okay, enough to go and take action. I spoke to one of my subscribers, okay, on the phone yesterday, as a matter of fact, and he's going through an entire judicial process, okay? And I'm talking about notices, letters, right? Executing these strategies that I literally teach, to the point where this company was 100% sure that they was going to not only try to collect on the debt, but they was going to repossess his vehicle. And they thought he was just going to lay down. This guy has probably created over 20 notices, created many affidavits, and literally uploaded them and submitted them to court. Okay? To the point where typically, most people cases get thrown out. Nobody will even bother with it. But the fact that his case is still open and those debt collectors are not responding, they are in deep shit. And it's nothing. And the thing that's the beauty about when you execute on these processes is the fact that when you start to play offense and they have to start to play defense, or the burden of proof is on them, now forget that you owe a debt. You have to prove certain things before you can start to collect on the debt, before you can say that this judgment or the ruling was even accurate. And these judges can't go against you. They cannot have a legal bias towards a debt collector just because they are trying to get paid. That would be unconstitutional. Okay? Now, here's some laws that can protect you in order or put you in a position to be able to cancel a judgment. So let's start by talking about Rule 60, relief from a judgment or order. A lot of times people think that they cannot challenge a judgment. Okay, they think that, damn, I have to be stuck paying this judgment, or this stuff has to be on my credit report. But under the federal rules of civil procedure, okay, Rule 60, you can essentially have relief from a judgment or an order. Okay, it says corrections based on clerical mistakes, oversights, and omissions. The court may correct a clerical mistake or a mistake arising from oversight or omission whenever one is found in a judgment, order, or other part of the record. The court may do so on motion or on its own, with or without notice. But after an appeal has been docketed to the appellate court, and while it is pending, such mistake may be corrected only with the appellate court's leave. Okay? Now, to break down essentially the grounds for relief, okay, and this is under B, okay? On motion, just terms, the court may relieve a party or its legal representative from a final judgment, order, or proceeding for the following reasons. Number one, mistake, inadvertence, surprise, or an excusable neglect. Okay. Number two, newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial. Number 3, fraud, whether previously called intrinsic or extrinsic, misrepresentation or misconduct by an opposing party. Number 4, the judgment is void. Number 5, the judgment has been satisfied, released, or discharged. Any other reason that justifies a relief. It also talks about the timing and effect of an emotion. Okay? So, this is under Rule 60. Says it right here in the law that you can overcome a judgment. So, all you naysayers that will be in the comment section and say, oh, well, it's in the law, it's written in the Constitution, and it is the job of the court system to uphold the Constitution. They cannot have legal bias. Okay? So, now we're off of Rule 60. How you can essentially build up that evidence so that you know for a fact that you can have relief from a judgment is when you dive into 15 U.S.C. 1692G. Okay? Debt collectors must validate a debt before collecting. Now, we talked about 15 U.S.C. 1692G in its totality. Okay? But if you've never received any validation and they sued you, that may be grounds to cancel the judgment. Okay? So it's important for you to, before you even get to this point, it's important for you to challenge debt collectors and get them to validate the debt before you get to court. But if not, you can actually start the validation process again. Okay? Get them to validate the debt. And if they're unable to validate the debt, then this is something that you can use as evidence as something that was either omitted, something that was a mistake, or even better yet, something that was fraudulent. And fraudulent is not something that should be taken serious. Okay? Or even a violation of the FDCPA is something that cannot be just ignored. Okay? Or else you lose the public's confidence in the system. And you may say, well, I don't care about that. Or they don't, but you can actually challenge the court system if they don't do this properly. Okay? So that's the validation of debt. So then we dive into UCC 3-305, which is defenses and claims and recoupment. This is the holder in due course rule. Okay. So essentially under this section, they must prove they legally own the debt. And if they cannot prove they legally own the debt under this subsection, they may lack standing to sue. Okay. So essentially you can demand the original contract and the chain of title under UCC 3-305. Now, what you guys don't understand is that the original contract has your wet ink signature. That's number 1. Number 2, the chain of title is a long list, a long packet of things that would show the chain of title. If they cannot provide this, then they don't have legal standing to sue. And also at the same time, if they if they can provide the chain of title, right, it doesn't necessarily mean that they legally are the holder in due course. Okay? You can look at the chain of title and it will tell you who's the actual holder in due course. So, understanding UCC 3-305, okay? You use this to your advantage so that you can demand proof under the UCC for them to provide information in regards to your loan or whatever they claim that they could judge you on. But I'll put it to you like this: if they cannot provide this information, you can essentially use this as something to vacate your judgment. Okay? The next thing I want to talk about is under 15 USC 1681, which is the Fair Credit Reporting Act. If you have a judgment on your credit report, okay, and the judgment was obtained without proper validation, you can dispute it with the credit bureaus and demand removal. You can send them the documentation from the validation. You can send them documentation from you challenging the holder in due course and they did not respond. You can send them the certified mail receipts and things of that nature, and essentially show and prove that there was no proper validation. And if there was no proper validation, how can they prove that something was 100% accurate? See, the thing about 15 USC 1681, which is what I love talking about, is because the public's confidence is super important to it, okay? But also at the same time, it says there's a need to ensure that consumer reporting agencies exercise their grave responsibilities with fairness, impartiality, and respect the consumer's right to privacy. And the thing about information is you determine what is private, not them. All right? So the beauty about the Fair Credit Reporting Act is not just its congressional findings. They have a list of sections here that when you read them and you fully understand them, you know they have a certain level of procedures that they must take in order to prove something to be verifiable, validated, but also at the same time, what disclosures they must give to you, but also at the same time, if they do not comply, how much they can be sued for not complying, or whether it's willful or it's negligent. An example of negligent noncompliance is you challenging them on the judgment and they only send you a letter saying verify, when they know under 15 U.S.C. 1681I they must provide the procedures in case of a disputed accuracy. Okay? So it's important for you to understand, even when you go to 15 U.S.C. 1681G, it talks about the disclosures. Okay? Then it tells you the compliance procedures under 15 U.S.C. 1681E. And the thing is a lot of times people don't dive deep into these laws. So what happens is they'll get a letter from the credit bureau saying, oh, it's verified, and they think that it's actually verified. No, that's not what the law says they need to do. They need to do more than just verify or say something is verified. You have to tell me who verified it. Okay, and was that even a reputable person to verify? Did they provide the information that I asked them for, which was, did they validate the debt that they got a judgment on? Okay, so the credit bureaus is another aspect, but other than that, you can essentially sue a company for improperly reporting information, for reporting inaccurate information. So not only did you violate the FDCPA, but you also violated the Fair Credit Reporting Act. Okay, because now this judgment is on my report and you never properly validated it. Okay, and last thing I want to talk about is the 14th Amendment. Okay, you have a right to due process. Okay, and under the 14th Amendment, it says it prohibits states from depriving any person of life, liberty, or property without due process of law, ensuring fair procedures and fundamental rights. So under the 14th Amendment, you have a right to challenge. You have many rights that I just laid out, okay? And it's your right to have proper due process. It's your right to be able to get fair procedures. If you go and you say, okay, bet, well, I never really had the time to challenge them on this, and you decided to do that, that will be considered fair, right? If you're taking fair action, then they should treat you the same exact way, okay? It is your fundamental right to challenge a debt collector on whether or not they should be collecting a debt on you. It's your fundamental right to ask for the chain of assignment. It's your fundamental right to for them to prove that they are the holder in due course. It's your fundamental right to even challenge a judgment or vacate a judgment. So if anybody says that you cannot do it and they are trying to tell you cannot do it, or they have some legal bias towards you just because you're not an attorney or you're not the debt collector that brings in them money every single day, oh, you'll be violating my 14th Amendment. Okay? So if he was improperly served, the judgment may be constitutionally invalid. And you can keep appealing over and over and over again. Hold that judge accountable now. Okay? So now we're about to talk about step by step how to cancel a court judgment. Okay? Now, before we do that, if you've gotten to this point of the video, make sure to like and subscribe to the video. Okay? You like the video, it's going to boost it on the algorithm. Okay? Either way, subscribe as well, because I drop bangers on a daily. Okay? Also, at the same time, if you got to this point, you got questions, drop it down in the comment section as well. You feel me? If you've gotten over 10 to 15 minutes a game, leave a like. Thank you. All right. Now, we're about to talk about the step-by-step how to cancel a debt judgment. Okay. Number one, get a copy of the court file. Okay. Visit your court clerk's office or website and pull the full file of the case. You want to look for the proof of service. You want to look for who sued you. And you want to look at what evidence they used. Okay. It's important for you to gather these things, and a lot of times you can just go online and get all of this information. But guess what? There's somebody who's going to say, well, I don't do the computer thing. Okay, pull up to the court office and get it. Well, I don't have time to go. Okay, well, all right, pay your judgment. Nobody's telling you to do something you don't want to do. But again, it's going to be at a point where your back is against the wall and you're going to have no choice but to take these actions. So take notes. Write this stuff down. Come back to this video multiple times you need to. You dig me? That's why I'm putting this information out there for free. All right. Number two, you want to file a motion to vacate the judgment. Okay. You want to use the state's version of Rule 60B to request that the court set aside or reverse the judgment. Number two, include arguments like improper service, lack of notice, no debt validation, fraud, or lack of standing. Okay, now you want to make sure you do your due diligence prior. Okay, but these are some of the challenges that you want to use when it comes to your motion to vacate a judgment. Step 3, demand validation from the creditor. Okay. While your motion is pending, send a debt validation letter under 15 U.S.C. 1691G. Okay. The reason why you do both at the same time is because you want to get the process started, because the legal process can take some time, but also at the same time, you want to get them to a position where they cannot validate the debt. So as soon as you get a response back from the court, whether they denied it or whatever the case may be, you can come back and say, hey, boom, I sent them a validation letter a month ago and they have not responded yet. Okay? If this is something that they could do, then they would just respond. Am I right or am I right? Yes. So if they can't validate the debt, you would use that as supporting evidence. Okay? Step 4. You want to dispute the judgment on your credit report. Use 15 U.S.C. 1681S-2 to file a dispute with all 3 credit bureaus. If the debt is invalid or the judgment was improper, request removal. So you show them the evidence. Okay? You can still go on the aspect of verifying, but you can show them the evidence of them not proving the debt was valid. You can show them your motions. Okay? And then lastly, prepare to show up in court. If the court grants a hearing, bring evidence showing no original contract. Make sure you show the improper service. Make sure you show how they violated the FDCPA. You gotta make sure to show their lack of standing to collect on the debt. Okay. You want to come prepared. Do your due diligence. Take as much time as you need to take in order to challenge a judgment. Now, I can't really speak to the fact of judgments that you've been had, but that you already started to pay on. But if you just got a judgment, you want to start taking steps now. Stop waiting. Okay? Don't wait them out. That actually puts you in a worse position. Okay? So if the judge agrees, they can vacate the judgment and remove the enforcement. Just make sure you're prepared. Just make sure you're showing the evidence. Just make sure you're using the tactics like the debt validation. Make sure you are getting well versed in these laws so that you can come in court and be able to state your claim. Make sure you understand what a chain of title is. Make sure you understand some of these things so that when you do start to reach out to them for this information, they can't just send you a bill statement and you think that that is validating the debt. A bill statement doesn't validate the debt. You got to give me a wet ink signature. I have to be able to go like this and potentially be able to rub it off. I can't get a photocopy. All right? And if they say, oh, you agreed to something, well, if that contract is invalid, if you didn't give me the proper disclosures, there's no way that you can say that this contract is not fraudulent. Okay? Because I can go back and I can start to challenge where the funds came from. I can challenge whether you are still the holder in due course. Okay? Now, don't let a default judgment ruin your finances. You can fight back with consumer law and with the right core strategy. Now, obviously, if the judgment is not that much, take care of it. Instead of going through an entire process, just take care of it. I'm a firm believer on doing what would make sense if we're talking about speed versus, the whole fight. All right. Now, if your car gets repossessed, yes, go after them. You dig me? Attempt to get your car back or keep them from being able to sell it and you don't make a profit from it. If it's a foreclosure, challenge them on that. It's not legal advice. If we're talking about a large lump sum of money that you know is going to garnish your wages, challenge them on that. Okay? Now, if you want my complete judgment cancellation guide, it's in the complete debt guide. Okay? Where I pretty much break down how to be able to challenge debt collectors using debt validation, understanding negotiable instruments, understanding consumer law, and also at the same time, I'm going to put a template for a motion to vacate the court judgment. Okay, I'm going to upload that onto the complete debt guide. Okay, so anybody who taps into the complete debt guide is going to be able to get access to my personal letters. Okay, and I will personally tell you to use this as an educational tool. Don't just submit this template and don't just submit the template. Use it as a tool to educate yourself. Don't just fill in the blanks and then submit it right away. Get comfortable with the knowledge. Understand what it's asking you first. See if you can develop your own. Okay. But other than that, it's a great educational and learning tool so you know how to put these motions together. So you know what to write and what to highlight in your motions. Also, if you're looking for more one-on-one help, now, let me be very clear and transparent, okay? This one-on-one help is geared towards fixing credit and helping you get funded to 100K. So if you hit that button down below, click that link down below to apply, make sure you are focused on your credit and we're not getting on the phone talking about debt, okay? If you have issues with debt, go grab the complete debt guide, okay? I'll put together an offer later where I can be able to link with you guys and be able to teach you guys. Actually, that's in the work right now. But as of right now, if you're trying to fix your credit, boost to a 750 credit score and get to 100K plus or funding, go ahead and put in that application down below. Okay? And then lastly, if you need help filing a motion or responding to a lawsuit and you don't want to learn, tap in with Solo Suit down below. Solo Suit is a platform that essentially will prevent judgments. Okay. Well, I won't say that I won't make any guarantees, but this will put you in a better negotiation position. This will put you in a position where you can be able to challenge the debt collectors before they actually file a judgment on you. This will take you through the debt validation process without you having to know every single thing, without you having to write the letters and things in that nature. Solo Suit will do the work for you. They'll even file it for you. Okay? So tap in with Solo Suit, okay? And then lastly, tap in with my Instagram. If you want to connect with me on a consistent basis, follow me on Instagram at biz.nick. Okay. My last question is, have you ever had a judgment entered against you? Are you trying to cancel it? Drop a comment. Let me know your thoughts. Let me know your experience. Okay. And lastly, like, comment, and subscribe. Turn on the post notifications. And if you got all the way to the end, comment the word discharge, and I'll see you in the next one.